Good morning and welcome to today's webinar, which seeks to highlight the current considerations for those living in the UK but with a non-UK domicile. The webinar is being recorded and a link will be available to you all. There will be a Q&A session at the end, so please pose your questions in the Q&A function. As a firm, we often advise individuals who are internationally mobile with multi-jurisdictional issues to consider. Our clients and prospects have historically included those looking to move to the UK and those looking to exit. Changes have been mooted by the Labour Party in their conference statements, which would naturally step into their pre-election manifesto. It is clear that a review or substantial rewrite of the favourable tax regime for non-DOMs is a key priority for Labour in gaining momentum before the upcoming general election. We will take you through the existing regime, our thoughts on how the landscape may change, and provide food for thought on how to structure residence and asset wealth moving forward. Given that our clients and prospects are considering their options on staying in the UK or leaving, we will outline the implications to you. A summary of the topics for discussion this morning are covered here.
Thank you, Helen, and hi everyone. So, to give an overview of the existing rules, we will take a moment to talk through residence, domicile, and then the favourable tax treatment available to UK non-domiciliaries known as non-DOMs. Starting with residence. UK tax residency is determined by applying the statutory residence test. The test provides greater clarity than the old residence rules, but it's important not to underestimate its complexity, and we recommend that professional advice is obtained before coming to or leaving the UK. Broadly, the test will look at the amount of time you spend in the UK and the connections that you have with the UK. Once UK residence is determined, the default position is that UK tax residents are taxed on the arising basis, subject to UK tax on their worldwide income and gains. It's worth noting that in certain cases, UK residents, so not just non-DOMs, might be eligible to claim split year treatment such that their UK tax exposure is limited to the UK part, the tax year of arrival or departure. Again, obtaining advice before coming to or leaving the UK could result in significant tax savings.
So what does domicile mean and what does it affect? Domicile refers to an individual's long-term home. It is the country with which an individual has their closest ties, personal, family, social, economic. We are born with a domicile of origin, which tends to come from our father. We may acquire a domicile of dependency if our father's domicile changes in the years of our minority. Alternatively, we may shake off our domicile of origin in favour of a domicile of choice by moving and severing ties with our country of origin. The process of claiming a change in domicile status involves the individual stating that they have acquired a domicile of choice elsewhere and providing strong evidence to support this claim. Their status may be reported to HMRC on their individual tax return, where this is relevant, yet the difficulty lies in that domicile is often not challenged until an individual has died and their estate position is reported to HMRC. It then rests with HMRC to challenge and analyse claims for non-domicile. Evidence of acquiring a domicile of choice outside the UK should involve regular documentation of future plans and evidence showing a follow-up on those intentions. They must be able to show that they intend to leave the UK and not return. The individuals seeking to lose their UK domicile will need to show strong and numerous links to their new jurisdiction, together with a severing of ties with the UK. A domicile statement demonstrating their intentions and the steps taken at a given point in time can be invaluable in providing the necessary evidence to HMRC in years to come. Perhaps for the family when defending the tax position taken by their late relative in respect of legacies left behind. We find that when we advise individuals who have been in the UK for some time, that individuals tend to focus on the watershed moments at 7 years, at 15 years, and we'll cover that in more detail in a moment. It is vital that specialist advice is taken in respect of domicile under general law to ensure that there remains a valid claim to non-domicile for the individual. We find that there is already increased scrutiny on long-term UK res non-doms. HMRC are becoming more aggressive, so with the focus of this presentation to one side, if you are a non-dom who has been in the UK for a long time, i.e. around 9 or 10 years, you should have a statutory domicile declaration in place. Thanks, Sonia.
Let's take a look at the current non-dom tax regime. Starting with income tax and capital gains tax purposes, non-doms can elect for favourable tax treatment in the UK, known as the remittance basis of taxation. Under this regime, non-doms can limit their UK tax exposure to their UK source income and gains. They will pay UK tax on foreign income and gains only if and when brought to the UK. A consequence of using the remittance basis is the loss of the tax-free personal allowance for income tax and the annual exemption for capital gains tax. Otherwise, there's no actual charge for claiming the remittance basis until you become what's known as a long-term resident.
So what does a long-term resident mean? After 7 years, an individual will be required to pay an annual charge to access the remittance basis. This is currently set at £30,000 per year, rising to £60,000 after 12 years of residence. Once an individual has 15 years of tax presence in the UK behind them, then the regime falls away and they're no longer able to claim the remittance basis. They must then be taxed on their worldwide income and gains as they arise. This is known as being deemed domiciled. There are inheritance tax implications too, and we'll cover those shortly. To benefit from the remittance basis, non-doms must make a claim on their tax returns. Non-doms have the choice to claim or not to claim each and every tax year. This becomes particularly relevant when the remittance basis charges start to apply. We often help clients to choose the most tax-efficient option for them on a year-by-year basis.
Domicile is also key for inheritance tax. Non-doms are subject to UK inheritance tax on their UK assets only. Their offshore assets, which are known as excluded property, will not fall within the UK IHT net. Settling assets into trust can be beneficial for non-doms, and Helen will discuss this topic in more detail later.
So what changes may we anticipate, and when should we be ready for that change? The long stop date for the general election is late January 2025, although there is all sorts of chatter about an October date having been penciled in. We know that change in the non-dom regime is a key flagship policy for Labour, and we should be ready for change within either the first 100 days of their administration or perhaps through the opening of a consultation period in their first budget. Change may take the form of replacement, abolishment, or some tinkering at the edges.
So, how exactly might those rules change? It's not yet clear, and any significant change may require consultation as part of a new tax regime's development and implementation. But talk in the media and amongst us tax professionals has suggested that the non-dom tax regime might be abolished completely, meaning no more favourable tax treatment for non-doms. It's been estimated that this would raise extra tax revenue of 3.2 billion from around 26,000 taxpayers. However, complete abolishment seems unlikely, given the risks that wealthy or highly skilled non-doms might decide not to move to the UK, and those that are here will leave the UK, which would then result in the tax revenue generated being much lower than estimated. Alternatively, and perhaps more likely, they may introduce a shorter term scheme for temporary residents. So, for example, the 15-year deemed domicile threshold might reduce to 5 years. And they might do this by mirroring regimes in other tax jurisdictions, which offer partial exemptions to incentivize people to move to their country. Or instead, they might introduce a reduced tax rate on remitted income for a temporary period, or even a reduced remittance basis, which will give a cap on the tax savings like there are caps on other types of tax relief. So, with the potential changes in mind, now is the time for non-DOMs to review their position and consider the planning opportunities that are available to them. Non-DOMs have the option to leave the UK and become non-UK resident. This might appeal to those with family or other connections overseas, or otherwise bringing forward their plans to move out of the UK. For others, their circumstances might not allow for them to move. For example, they might have children at school in the UK, or elderly parents, or they may just wish to remain in the UK for now. Finally, there's the option of becoming dual resident. This could work well for those who have ties to both the UK and another country. What are we seeing our clients discussing and ruminating on given the current climate? They see the current point in time as a moment for action. Do they shore up their wealth with currently recognised wealth protection structures? Or do they seek to understand the implications of a move from the UK to a different jurisdiction? In each case, we would recommend that non-DOMs consider the options available to them sooner rather than later, so that there's sufficient time to plan and take action. Helen will discuss further, but we would be happy to talk through these options with you individually and on a case-by-case basis.
So a clear option is to make plans to leave the UK, severing UK tax residency. Specialist advice should be taken to work through a blueprint for how to facilitate the move, optimise the timing, and to look at the position as regards days in the UK post-move. We find that clients naturally focus on taking advice in their country they're seeking to move to, rather than on taking advice on leaving the UK. This can leave gaps in the advice and a lack of certainty over the position. When an individual considers leaving the UK, it is necessary to understand how the statutory residence test will treat them in the year of departure and in later years. An individual is resident if they spend 183 days or more in the UK. This automatic test is typically easy to manage. For leavers, individuals who've been resident in the most recent 3 years, then the threshold for residence drops to 16 days in the UK in the current year. Over that threshold, and the individual potentially retains their UK residency position. There is an exception for individuals who leave the UK to work under a full-time work contract abroad. If they're present in the UK for less than 91 days in the tax year, then they will not be tax resident here. This test requires an employment contract with duties abroad, and for the days in which they do return to the UK, they must ensure that they do not work here for more than 30 days. Other than the 183-day test mentioned, an individual may alternatively be UK resident if they have a UK home, but no overseas home, or they work full-time in the UK. Therefore, it is not simply a matter of just counting days, and there are key considerations to take into account when wishing to leave the UK and to be determined as a non-UK resident. The complexity of the rules notwithstanding, the UK tax system requires resident status to be self-assessed. It is therefore important that individuals maintain records to support their position should HMRC ever question their resident status. What constitutes appropriate records will vary from case to case, but may include evidence of travel to and from, records supporting particular working times and locations, and records showing how a particular property has been occupied. Turning now to employment issues. To be considered a full-time worker in the UK for the purposes of the SRT, the individual must, of course, work in the UK, although the period over which this work covers need only be 1 day in the relevant tax year. The contract must cover a 365-day period, and they must spend 75% of their working time here in the UK. Worth noting that the contract does not need to be with a UK employer. For an individual to satisfy the non-UK work test, they must work under a full-time contract, which averages 35 hours a week. Watch out for absences and holidays as they drag that average right down and create breaks in the employment. The contract does not need to be with a non-UK employer. I think you can tell that the rules around working contracts can be complex and advice should be sought. The UK home test may also trip people up. A UK property can rent to an individual UK resident if they spend time at that property on at least 30 days. That's not counting midnights, it's just time during the day. This can be protected against by also having a non-UK home where that property is available for at least 91 days and it must be used as a home. It's possible that an individual's resident status may remain undetermined to the resident and non-resident tests in the SRT, in which case we turn to a combination of days and connection ties to determine status. This is known as the sufficient ties test. We look at whether they have a UK resident family, are doing substantive work in the UK, have accommodation available to them, spend 91 days here in the past 2 tax years, and finally, whether they spend more time in the UK than they do in any other single country. UK resident family includes spouse or common law partner and children under 18. There are particular rules where those children are in boarding school, which we won't dwell on here. The status of one spouse can have an impact upon the other. Accessible accommodation, that's a home or a house that is available for use. It may be an Airbnb, the home of a relative, having the keys to a parental home, for instance. It's the availability that provides the tie, not the actual usage. Substantive UK work includes employment or self-employment, and 40 days is considered substantive. The definition of a workday is 3 hours or more. It includes reading emails, agreeing meetings, Teams calls, travel, etc. Once the ties are determined, the individual then considers how many days they have spent in the UK or plan to spend to determine residence. So for an individual with the work tie, accommodation tie, 91-day test tie, they will be resident if they spend 46 days in the UK in the current tax year. If they can drop 1 tie, then they can spend up to 90 days in the UK once more this year without being tax resident. Please note that the UK has anti-avoidance rules that kick in should an individual leave the UK, breaking residence in accordance with the SRT, but return within 5 complete tax years while realising gains or certain sources of income while they're non-res. This is known as temporary non-residence. The rules are designed to capture the sale of, say, a significant asset while temporarily outside the UK tax net, or catch income from closely held companies where the income was generated while the UK resident. We are well placed to advise on the tax regime in alternative jurisdictions, and we do so by working together with our member firms at HLB, our international network. Individuals should keep in mind that the destination jurisdiction needs to, of course, be workable from a personal, family, and business perspective. Practical considerations might include applying for the right visas, taking steps to overcome language barriers, and putting in place arrangements for family and living. Getting the timing of their move just right can make a huge difference to individuals realising optimal value and maximising tax savings. Retaining UK residency is a really good option for many, and there are various tax reliefs and structures that may be considered to ensure that the family's UK tax position does not become prohibitive. Relevant reliefs include business investment relief, which currently protects remittances from taxation. Hopefully that will stay. EIS, CDIS, and various business reliefs for capital gains and inheritance tax. Settling assets into trust may be beneficial for non-doms, and historically the moment for planning has been triggered either before arrival, or at 7 years, or at 15 years. The change in environment really pulls that moment forward. An excluded property trust is a trust which is excluded from UK inheritance tax. An EPT may be created with non-UK trustees or indeed with UK trustees. The preference tends to be for non-UK, as this structure provides additional UK tax benefits in terms of capital gains tax deferral and various income tax implications. Settling assets on trust means moving those assets out of personal ownership, and there are associated legal and practical considerations. Please take bespoke advice. Insuring against the potential UK IHT on worldwide assets is also a good option to minimise the effects of being caught in the UK tax net, and the cost of premiums may be a viable option as an alternative to a trust structure. Our colleagues at Menzies Wealth Management are really well placed to advise here.
In particular circumstances, dual residence might be the route forward. This takes effect where domestic rules for tax residency are met in 2 jurisdictions, and the relevant tax treaty, where applicable, dictates the position. The tiebreaker rules under the relevant tax treaty will need to be applied to confirm which country has the taxing rights. Tiebreaker rules consider the following tests in order: 1, where the person's permanent home is based; 2, their centre of vital interests; 3, their habitual abode, i.e. where they spend most of their time; 4, their nationality; and lastly, if none of these tests are conclusive, then the position must be settled by mutual agreement between the relevant states. It's worth noting that these rules are a series of tests. Once you've satisfied one of the tests, you do not need to continue with the rest of them. Once the treaty residence position is reached, the rules in one jurisdiction will take precedence over the other. In the right circumstances, this approach may provide more flexibility for the time that you can spend in the UK. Treaty residence needs careful consideration and bespoke advice.
Okay, thanks, Sonia. So we're now going to pop up the poll, which gives you the opportunity to tell us what you'd like to understand more about. Thank you. Right, moving on now to our key takeaways. First, each individual considering their options. Normally, a good starting point is to consider their current taxation position. Think about maximising any reliefs that they're currently entitled to. Think about making the most tax efficient remittances to the UK under the current regime, looking at the various, hopefully segregated funds that they hold outside the UK. Focus on family and business needs. every decision shouldn't necessarily, of course, be tax driven. Consider wealth structuring. Does wealth structuring through something like a trust, does that give you the opportunity to remain in the UK with your current lifestyle while optimising your tax position? Alternatively, think about different jurisdictions that you could move to. Once an alternative jurisdiction is chosen, or perhaps a number of alternative jurisdictions are in the pot, compare those positions with the net position after tax take. We hope you found today's session informative, and we look forward to speaking with you on an individual basis. Just got one question coming through on the Q&A. We're part of an HLB network. Yes, I can tell you more about that. So HLB is an international network of independent firms that are across a huge breadth of jurisdictions. It's one of the biggest international accounting networks in the world. And what we do is we have really good connections, obviously, with a good number of people around the world. And we reach out to those individual firms at times when we might need multi-jurisdictional tax advice. Okay, if there are no other questions, we'll wrap up today's session, and we hope to speak with you individually very soon. Thank you very much. Have a good day.
Thanks, everyone.